What is an inter vivos trust in elder law? Have you ever wondered how to manage your assets effectively while you are still alive and ensure they are distributed according to your wishes after your passing? This is where an inter vivos trust, also known as a living trust, comes into play. This legal arrangement is created during a person's lifetime, allowing them to transfer ownership of assets into the trust. The person who creates the trust is called the grantor or settlor. They set specific instructions for how those assets should be managed and eventually distributed. An inter vivos trust becomes effective immediately upon its creation. It continues to operate during the grantor's life and after their death. In the context of elder law, these trusts serve as important tools for estate planning and asset management. One of the key benefits is the avoidance of probate. Assets placed in an inter vivos trust typically do not go through the court-supervised probate process. This means fewer delays, lower costs, and more privacy regarding financial matters. Another significant advantage is the management of assets during incapacity. If the grantor becomes unable to manage their affairs, a designated trustee can step in. This avoids the need for a court-appointed guardian or conservator, making the process smoother for everyone involved. Inter vivos trusts also offer flexibility. They can be revocable or irrevocable. Revocable trusts allow the grantor to change or revoke the trust at any time during their life. This is great for adapting to changing circumstances. On the other hand, irrevocable trusts cannot be altered once established, providing protection of assets from creditors or Medicaid spend-down rules. Privacy is another important factor. Unlike wills, which become public documents during probate, trusts remain private. This helps protect the grantor's financial affairs and family matters from public scrutiny. Additionally, trusts can restrict access to assets, which can help prevent financial exploitation, especially among older adults. From an elder law perspective, inter vivos trusts are particularly useful for planning long-term care. By placing assets in a properly structured trust, seniors can preserve wealth for their heirs while qualifying for government benefits like Medicaid. Setting up an inter vivos trust involves a few steps. First, you need to draft a trust document outlining the terms, beneficiaries, trustee powers, and instructions for asset management. Next, you will transfer ownership of chosen assets, such as real estate, bank accounts, or investments, into the trust. It is also essential to name a trustee to manage these assets during the grantor's life and after their death. Often, the grantor serves as the initial trustee, with a successor trustee designated. Lastly, it is wise to review and update the trust as needed to reflect any changes in circumstances or wishes. An inter vivos trust is a practical tool for managing and protecting assets during a person's lifetime and beyond. It provides a means to avoid probate, maintain privacy, plan for incapacity, and secure financial well-being for loved ones.